When you hear the term Islamic criminal law, or Sharia, what's the first thing you think of? For a lot of people, it's a list of severe, unchanging punishments, something carved in stone ages ago. But the real story is so much more complex, and frankly, more interesting. So, which is it? Is it a fixed ancient code, or a surprisingly flexible, modern system? Let's dig in.
Okay, so let me start with a real story from 19th century Egypt. Two guys get caught stealing seeds. They even admit it. A local court does what you'd expect and sentences them to amputation. That's the classic punishment for theft. But then it goes to a higher court, and that court completely overturns the sentence. The men don't get punished for theft at all. Now that feels weird, right? It just doesn't seem to add up, and it forces us to ask a really important question.
If the rules seem so black and white, and the punishments so harsh, why would a court bend over backwards to avoid them? This is the central paradox we need to understand. And to do that, we have to look at how the system was first set up, how that system got dismantled, and how it's being rebuilt today in some really controversial ways. So, here's our roadmap. We'll start with that surprising verdict we just talked about. Then we'll break down the 3 different paths to justice in this system. We'll see how it worked in the real world of the Ottoman Empire, look at what happened when colonialism showed up, and finally get into its controversial comeback in our time.
All right, first things first, we have to get this one idea straight. Islamic criminal law isn't just one thing. Think of it less like a single highway and more like 3 different paths to justice. And each path has its own set of rules, its own philosophy.
So here are the 3 toolkits. First, you've got qisas. This is for crimes like murder or assault. It's basically an eye for an eye, but the real power is with the victim's family. They can demand equal punishment, or they can ask for money instead, or they can just forgive the whole thing. Then you have the hudud crimes, stuff like theft or unlawful sex. These punishments are fixed in scripture, and they're seen as claims of God, so an individual can't just forgive them. But, and this is a huge but, the standard of proof to actually convict someone is astronomically high. Which leaves the third and biggest category, ta'zir or siyasa. This is basically the catch-all for everything else, giving the ruler the power to punish pretty much any act to keep society in order.
The whole system, especially those severe hudud punishments, pivots on this one absolutely crucial concept. Shubha. It means doubt or uncertainty. It comes from a famous saying of the Prophet Muhammad to ward off the fixed punishments with doubts. What this means in practice is that any little bit of uncertainty about the facts of the case or even how to interpret the law is enough to prevent the fixed punishment. It's like a legal master key. And that's exactly what happened with our seed thieves. The higher court found shubha. They asked, was the value of the seed certain? Was it technically theft from a secure location? With that much doubt, the amputation was off the table.
So, that's the theory. But what did it look like in the real world, running a massive empire? For that, let's turn to the Ottoman Empire. For hundreds of years, they used this system, and you'll see it wasn't just one path to justice. It was 2, running side by side.
Think of it as 2 arms of the same government. On one side, you have the qadi, the judge. He's the by-the-book guy. He has to follow the religious law to the letter, including that super high standard of proof. Because of that, getting a hudud conviction in his court was incredibly rare. But then you have the other arm, the political authorities, like the governor or the chief of police. They operated under a different logic, called siyasa, which is all about public order. They could use things the qadi couldn't, like circumstantial evidence or a suspect's bad reputation, to make a decision.
So let's trace how a case might actually move through this system. A crime happens. It goes to the qadi's court first. The judge might be totally convinced the suspect is guilty, but he just can't get the 4 eyewitnesses the law requires. His hands are tied. But he doesn't just say, "Oh, well, you're free to go." No way. He writes up a report and sends the suspect over to the governor's office. Now, the governor, acting to protect public order, can punish the guy. Not with a hudud punishment like amputation, but with something else. Maybe a harsh flogging or a long prison sentence. It was a built-in safety net to make sure guilty people didn't just walk on a technicality.
So you have this really complex, nuanced system that governed one of the world's great powers for centuries. And then, in the 18th and 19th centuries, it runs headfirst into European colonialism, and that collision would basically shatter the whole thing.
This quote from a British official in India really says it all. He sees a case where a father kills his own child, and under Islamic law, the father can't be executed for it. He is absolutely shocked. He calls it repugnant to natural justice. From his point of view, the system was broken. But from the perspective of the Islamic jurists, this was a settled legal principle. The British looked at a system built with safeguards like shubha and didn't see mercy or flexibility. They saw loopholes, and they decided the whole thing had to be fixed.
And that led to this weird hybrid system that scholars now call Anglo-Mohammedan law. British judges basically took over and started tweaking the system to make it look more, well, British.
That high bar for proof, they lowered it. Those crucial safeguards like Shuba, they got rid of them. They replaced the judge's discretion with fixed prison sentences. For a while, they kept the name Islamic law, but they had completely hollowed it out from the inside, before eventually just replacing it wholesale with their own legal codes.
So after the colonial era, most of these newly independent nations just kept the European laws they'd been given. But then, starting around the 1970s, that began to change. A new, powerful movement started pushing to bring Islamic criminal law back.
And this wasn't just a fringe idea. It was a wave that swept across different parts of the Muslim world. It popped up in Libya and Pakistan in the 70s, got a huge boost from the Iranian Revolution, and kept going into the 2000s when states in northern Nigeria started passing their own Sharia penal codes.
Now, the reasons for this were often deeply political. It wasn't just about law, it was about identity. It was a very public and symbolic way of saying, we are rejecting the legal systems left behind by our colonizers, and we are returning to what we see as authentic, God-given law.
But this modern revival immediately set up a huge clash. On one hand, you have decades of international human rights law, which clearly states that no one should be subjected to cruel, inhuman, or degrading punishment. And on the other hand, you have these new penal codes that specifically prescribe punishments like flogging, amputation, and stoning, arguing they are divine commands. The two are just fundamentally at odds.
And the conflict goes way beyond just the punishments themselves. It gets into other areas, like the principle of legality. Can you punish someone for a vaguely defined sinful act? It raises issues of gender discrimination, where a woman's testimony might literally be worth half a man's. It touches on freedom of religion, with apostasy being a crime. It even affects the age of criminal responsibility, which some codes set as low as 9 years old for a girl.
Even the basic idea of what counts as evidence can be totally different. Take this procedure called kasama. Imagine a murder in a small, tight-knit community. There's no forensic evidence, no eyewitnesses, but everybody knows who did it. Well, under kasama, the victim's family can actually get a conviction if 50 of their male relatives will take a collective oath, swearing the suspect is guilty. 50. That number represents a kind of communal certainty. It's a justice system built on social truth, not just physical evidence, and it really highlights the deep differences in legal thinking.
Okay, so after all that, let's go back to the question we started with. Is Islamic criminal law this rigid, ancient code, or is it a flexible, living system? And the answer, as you've probably guessed, is that it's been both. Historically, for centuries, it was an incredibly dynamic and flexible system. The concepts of Shuba and that two-track justice system gave it a lot of room to maneuver. The irony is that many of the modern attempts to bring it back have treated it as a much more rigid and fixed instruction manual, sometimes stripping away the very flexibility that made the old system work. It just goes to show you, this isn't a dead tradition, it's a dynamic, living field where scripture, politics, and society are always in negotiation.
In the end, this story is still being written. The law is still being debated, applied, and fought over across the world. And as it continues to evolve, the central challenge isn't going away. It's this. How can a legal tradition with its roots in 7th century revelation be reconciled with 21st century ideas about universal human rights? That is the profound, difficult question at the very heart of this entire debate today.